were talking about objections and responses, and we want to pick up on the person who's answering these questions. Who is the person who should sign these? What if it's sent to a company? And what if there are two people that have knowledge? Because interrogatories are commonly not just answerable by one. If you asked 100 lawyers, 99.7 of them would say one person can sign. The answer is every person who participated in that response has to sign under oath. So if there are multiple people, you have to say that. And if they don't, which no one does, let me show you again Exhibit A. I know you didn't like when I talked to you about this 2 hours ago, but I wanted to ask you, throughout this depot, you've said that the CEO knows more than you do about these answers. Any reason why he didn't participate in answering these interrogatories? Only one of two answers. Answer number one, he did. Answer number two, he did not. Answer number one, well, he did. Well, how come he's not signing these? How can it be valid answers to interrogatories and verified when you're swearing? Are you willing to swear to everything that he said? Are you willing to go under oath and risk a perjury charge that you know every single thing the CEO said? If they say yes, I'm like, what's it time for? Celebration! Okay? Great. So it's very important that if there are multiple people that are responding, the rule prescribes that you have to let people know that. No one knows that. I'll bet you can't name me in the history of your career somebody who signed interrogatories and had 3 signatures from 3 different people. Yes, ma'am.
A lot of times in interrogatories, you put the client's name as the name of the person that's done the interrogatories, but you'll also put the attorney's name on there. So you're saying that if the attorneys are involved in doing it,
The question is,
are they signing?
the question is, who are the people that are answering these interrogatories? Now, you can have people who are not the actual party to whom it's direct sign, okay? But if they're participating in answering the interrogatories and they're not signing under oath, then how is any of the answers valid? Which part of this, oh, you said your lawyer was involved in this, or you didn't do this, your lawyer did it at the depot? Oh, I didn't know that. You know, I'm looking at the signature. This looks like your signature. Did he sign somewhere else? Looking at video, see video? So theoretically and technically and under the law, every person who participates in answering those has to do that. If the lawyer answers the question, some of these cool lawyers who think their pants go on a different way, or I guess it could be a man or a woman when you say that, they, will say they answered the interrogatories when you ask that question if it still stays in your requests. Okay, great. I'd like to take your depot. Judge, these are fact interrogatories. I am asking for the support in the documents that the listing. This guy's coming. He's not offering legal opinions. These are fact interrogatories. These are factual questions. I want to know what the support is for allegation number one. I get one of two things, Judge. Be happy to go any way you want to go, Judge. We can, 1, throw out the case. 2, we can ask the guy who claims he has the evidence or she has the evidence to tell us what the basis of their answers are. But they can't hide behind, I'm a lawyer. And you will win that a lot. Yes, ma'am.
But in situations where the questions are not fact-based, but they're asking for legal conclusions.
Okay, let's talk about that. The question is, what happens if the particular questions ask for things which require legal conclusions or require some legal things? Well, the lawyer can certainly answer that. Anybody can answer anything. The question is, if you ask for somebody to give you the facts which support the allegations or the facts which support your claim in paragraph 23 that the bill was excessive, unreasonable, or wasteful, and the lawyer wants to claim that there's something legal in there, that lawyer is going to be a witness. First of all, there's no attorney-client privilege on that because you're asking for support for the allegations of the complaint, and you can't have that sword and shield. Or alternatively, they're going to have to explain why this is truly just a legal conclusion that is impossible for someone to answer, and they can argue to the judge, and I wish them the best of luck. Because if it goes to an allegation, if it goes to a defense, I'm not aware of any privilege. You can't even take the fifth unless you want your complaint dismissed. If you're claiming, hey, they stole my book, and I say, hey, what's the support for the fact they stole the book? And the guy says, I'm not telling you, because I'm going to get a lawyer who's going to say, well, the heretofore thereafter before mentioned general objection to the objections, then I win. Summary judgment. So if you don't believe it, try it, and you'll see. Think about it yourself. How would you argue as a lawyer? Well, Judge, I had to answer this. It called for a legal conclusion. Okay, Mr. Major, call for a legal conclusion. It says here, please state the facts that show which bills were unreasonable or unnecessary. And you're claiming in your complaint that they committed fraud by overbilling and unreasonable and wasteful billing. What's legal about that? Somebody, Mr. Major, on your side is going to testify to that. I don't care who it is. Since you seem to be the one who wants to talk, you're going to be the witness. But if you want somebody else, but you can't say, I am suing you for this, but I'm not telling you. Okay? Works every time. When you are responding and you have these multiple party situations, just remember, if you're the party who's propounding those interrogatories, make a note to your lawyer. Make sure that that lawyer asks them, who is every person that you're aware of that looked at this? And if you want to be more particular, okay, you say that the lawyer helped you, right? Okay, why don't you take a look at that, and why don't you tell me which parts the lawyer helped you on? Which words are yours? Go ahead, we can go sentence by sentence, word by word, answer by answer. Tell me which ones that you answered without any help from anybody. I want to ask that because I want to find out. If they say the lawyer answered everything, just like in my depot with the guy who says, I don't know anything, it's my lawyer. After our celebration, I called the guy and say, are you going to be the material witness, in which case you're disqualified? Or are you going to throw out your case, in which case you got to pay me $1 million of fees? Which would you prefer? I'll go either way. So it's very important to understand that when you're responding, they have a duty, and it's straight, and it's under the law, and it's clear. Finally, the way in which I respond can also be governed by law. In other words, I don't have to put the answer if that answer can be clearly found in a document. So in other words, if you ask for can you please state what is in your tax returns as to your income and your deductions and your this and your that, you can say, I'm attaching a copy of the tax return which has the information provided. Okay, sounds good so far. Everybody's with me now. When the person asks, please provide me with a list of the documents, or when I ask you, please tell me all of the facts which support allegation number 1, you cannot say, please see clump of 400 documents stapled and handed to you. You cannot force the movement to glean the answer from documents. You can direct them to documents. If it's business records, for example, you could say, those are contained within these business records, these personnel files. Okay? You can ask for production of those, but they are found, the answers are found in there. So long as you, who's propounding it, has the ability to glean the answer from the information. Okay? And it's sort of a degree, a sliding scale. You can't blindly direct them to documents, but at the same time, you don't have to write everything down that you need to do. How about this one of my favorites? Not in our possession at this time. First of all, at this time would be redundant, because if they're not in your possession, would you say not in your possession in the future?
Right.
Not in your possession in 1973?
Right.
It's like jumbo shrimp. It's like oxymoronic. Okay? Okay? So, I don't understand that, but when we get that, celebration time! Okay. When somebody says it's not in their possession, the law is that you cannot use that is in someone else's possession if you gave it to them. if they got there through means which you could acquire that information. Now, you're not required to go back and get documents that were initiated by the third party, but if you gave those documents to the third party, oftentimes they give them to somebody to avoid producing or responding. You cannot use that as a grounds for not responding. And we'll talk about that a little more when we get to production. So you've gotten a sort of a scale from how we're crafting and how we're doing things all the way through. Now, if you want, you can send out expert interrogatories and computer interrogatories and fact witness interrogatories. You could do that. But I would recommend to you that you do numbered interrogatories. And if you want to put that's expert interrogatories and you're in your fifth request, fifth set of interrogatories, then you can put fifth set of interrogatories and then in parentheses underneath it, expert interrogatories. But I still think the numbering system will help you well, whether you continuously consecutively numbered. The last part of this interrogatory answers is, how about this objection? Objection exceeds the limit of number of 30 plus subparts. Love and kisses me. Okay. What's a subpart? And how can I use that to get into a free movie? Okay. Subparts have been a big area of debate because probably most people think they know what a subpart is, but they don't really know, and there's not many lawyers out there that have done the research. The rule is, actually Florida uses something called the logical relationship test, but the rule is that is the question derived from the initial question, or is it a question that can stand alone? Example, how many accidents were you in between the years of 2005 and 2012? For each accident, please state the location of that accident. That's not a separate question, right? Because it's a subpart asking somebody just to give me more details about that. So you use a logical relationship test. If it can be separated, there's a couple of courts that say that if I say, please identify which items on which bills are duplicative, unreasonable, and wasteful. Second item, please list all the documents that are supportive of that request. Well, theoretically, that list of the documents could be a separate question because it's not subsumed within the first. So generally speaking, you look at, is it logically related? Am I asking for time, place, location, other things about the main question, or am I asking a completely different question? Most of the time, you will find that your subparts are asking to break down the main question. And those do not count as separate interrogatories. Again, we have case law for you if you need it, but it is going to be put in every state in most of the case law. It travels mostly around the federal circuit, federal courts right now. But it's very important to understand that when you're doing numbers and subparts. Well, okay, great, Scott, that's great. Subparts, well, how do I avoid that? Well, what if you have multiple parties? If you have multiple parties, do not send out, I have two plaintiffs. I do not send out my first request for production from the two plaintiffs. Ever. I send out a request for production from the first plaintiff for 30 questions and a request for production for the second plaintiff, 30 questions. Which would you rather have? 60 questions, 30 questions. 60 questions, 30 questions. Anybody see night and day? Yeah. With me, without me. With me, without me. With me, without me. Obviously, you want the opportunity to have more questions. And what will happen is after you send out your first interrogatories, there are going to be more questions that are going to come up. So when you have multiple parties, it's very important to think about whether or not it's appropriate for you to break them into parts so that you can get more questions. Don't make that mistake. The defendant's defending, and the defendant has affirmative defense of comparative negligence against both plaintiffs. Why do you have to, both plaintiffs have to ask? You could just say, please tell me the basis for your affirmative defense that says comparative negligence. Fine, tell me what that is. I don't care what it is. I don't need to have both plaintiffs ask the same question, which is another thing people do. They send out two requests, and they're the same request with the same amount of interrogatories, and they're just different plaintiffs. Well, what is that all about? Okay. Commonly done? I'm not talking about the food of the intellectual chain there. Okay? So just pay attention to that and see what is going to be best for you. So now we've taken you from the beginning of interrogatories through them and into the answers. And the last thing about interrogatories, and some of this will overlap with the other material, is I don't get the answers I want, what do I do? Okay? If you don't get the answers you want, depending on the jurisdiction, you may be able to do different things. For example, in Broward County, Florida, if somebody does not respond to interrogatories, you can get an ex parte motion to compel, meaning you can go directly to the court without telling the other guy, and you could get an order compelling them to answer, not respond, compelling them to answer. All objections are waived. But if they file any kind of response, then you have to file a motion to compel. You should always make an effort beforehand to communicate with the other side. We've gotten your objections. We respectfully disagree. We think we're asking you simple questions. You write a little brief thing. You don't just say, this is our good faith duty. Do you want to respond? No, great. Why? Every piece of paper from today on that you all use, it's going to go in front of a judge. So when you write things so that when I hand it to the judge says, wow, what an eminently reasonable guy he is. He actually gave you the reasons ahead of time before he filed the motion, and he explained that if you wanted to limit it, you could, and he explained that he would bear your children, and he explained that, I don't get it, counsel. A lot stronger than, he's doing this, objection, I don't like him, he's a liar, no, he's a liar. Heads or tails, guys. So when you write letters, dear so-and-so, I don't ever write the words, this shall confirm. Eliminate that from your vocabulary. We'll talk about that later. But I write, we're writing you in response to the objections to interrogatories that we received on X date. First sentence of every letter you ever write is, what is the letter about? We're asking if you would kindly take another look at them and provide us with better answers, and more particularly on number 2 and 5 and 6. Some of them may be valid objections you're going to, but 2 and 5 and 6. We've asked number 2 just for the names of the witnesses. We don't understand. We'd love for you to tell us why, so we don't have to file a motion. Da-dum. What happens is, even if they don't do it, when you show your good faith, you say, Judge, I'm arguing the same thing that I sent in the letter to him. And it's very powerful. And it also makes a good record. And it's great to show your clients. And when you start filing motions for sanctions and you start numbering those, and the person is doing it over and over again, it becomes very, very powerful. Okay? When the guy on the other side, sets a unilateral hearing and doesn't tell you, and you do it once, it sounds like, well, it's nothing. But if he does it 6 times, and you've written him 6 letters about it, that's really powerful. So that kind of approach helps you in filing the motion. If you guys want, later on, we can talk about strategies on what to put in the motion, how to argue it, and case law. But let me move to production. Requests for production. What do the requests for production do? The request for production ask for documents, things. Theoretically, you are asking for often documents, but you can also ask for the land, for the computer, for the body. I want to do an inspection. I want to do an IME. I want to go into the real estate property and see the damage of the house after the storm. I want to. That's all consumed within production requests. So it's important to know that we need to ask ourselves, well, what do I need? Well, I can put a request in that says, please provide me with all the documents that are responsive or that you referenced in your interrogatories. You could say that. But if I haven't numbered my interrogatories, boy, would that be a difficult one. And if I haven't been as special in terms of my specificity in the way in which I write it, it might be difficult. So I might want to say, please provide any documents, or please provide the documents that you identified in interrogatory number 1, the second request for production, which include bum. Any lack of clarity on that? Anybody claim that's vague? Anybody claim that that's overbroad? So take the extra time, and instead of just using these silly things that produce all the documents that are responsive to your interrogatories, loser, put the actual language from that. Very clear, very easy, very, see how I'm squeezing down. Hard to object to that. It's your documents. I didn't tell you what to write. Your documents. So when you ask for things, you can ask for things based on other types of things, such as other discovery requests like interrogatories. When we get to admissions, if somebody denied something, you could say, please provide the documents that support your denial of admission number 1 that asked you to admit, dum 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 dum, end of quote. Because you know that particular one requires some documents for them to deny. So in production requests, I want to understand what I'm asking for. I want to, again, squeeze it down. I want to use definitions where necessary. And I want to make sure I understand what I'm talking about. When you ask for production of everybody's computers, you are not going to get that. If you ask a production of Joe Smith's laptop and the information contained in emails that were sent to Bob Smith and from Bob Smith for the year of 2012 that relate to the subject matter of your affirmative defenses or the complaint, you can get that, right? Harder to argue. This is just a fishing expedition. He's invading our computers. So you want to make sure that when you're requesting these kinds of things, that it's very important that you make the requests that are going to be very, very tight and very hard to object to. I can ask for things like, please produce the documents that support your affirmative defenses. Or I could say, please produce the documents that support affirmative defense number 3, that you have a collateral set-off. Collateral set-off is there is some money that's been prepaid for some reason, and that should be set off. I don't think that's kept in somebody's head, is it? It's got to be reflected in some medical bill, some document, something. If they say none, then I'm moving to strike or for summary judgment on that affirmative defense, right? So very important to understand that each one of these is triggering another event if they don't respond. So when I ask for documents, very important. I want to make sure I'm asking for documents that are tailored to the specific facts of this case, that are tailored to what is the person answering if you sent out interrogatories. If you didn't send out interrogatories, what are the food groups of information that you want? And instead of doing 60 requests for production, try to do them very, very refined, where if you're asking for different types of records from a personnel file, instead of asking for the personnel file, ask in question number 1 for the personnel file, the parts of the personnel file that show the disciplinary record, the parts of the personnel file that show rewards, bonuses, achievements, the parts of the personnel. Now when you go to court, you can lose one and win 4 others. But if you ask for the personnel file, if you ask for the whole computer, every computer at the law firm, at Greenspoon, Martyr, Gunster, Yoakley, Smith & Jones, you're probably not getting them. So whenever you can, and you can even be more refined as you get more sophisticated, and you could say that have the keywords in them of football, loser, happy, and winner. So you could actually tell in the court, that's what I want the search of, and you could have an independent person do it or they can do it. But the concept is, do you see how I'm being much narrower? I'm now focusing in and I'm asking for documents which are going to support those defenses or documents which are going to support the complaint. I'm also going to ask for documents that anybody references. You take a depo, the guy says, yeah, I got it somewhere, wasn't part of the subpoena ducis tecum, or I know you asked me to produce documents in the notice ducis tecum, but I don't have all the documents. Okay, what is it? It's a bank statement. Okay, do you remember where that's located? Yes, I probably have it in my house. I go back and say, please provide us with the bank statement that you referred to in your transcript at 1:27 p.m. on Tuesday, March 5th, relating to the Bank United statement. They can't say, what Bank United statement? I have 6 Bank United accounts. So when you're doing this, pay attention to that specificity. It's very impressive, and it squeezes down the ways that people can do things. So if you do that now, what am I doing? I've captured some data in my interrogatories. Now I'm getting some documents that are either supporting or rebutting it. I've asked questions before. Please provide all the documents which you think harm your case. Please produce all the documents you think rebut your case. Let them object. I'm going to hand the production request. Do you, Mr. Sir, you see this production request? I know your lawyer objected. He's a very good lawyer, and it's wonderful and great. But is there any document that you're aware of that technically, in any way, shape, or form, you think could hurt you? Absolutely not. Or, well, yeah, maybe there is, but I just don't think that it's interpreted that way, Mr. Major. Okay, what's that document? So you can get documents which harm a people's case if they're relevant out there. Now, you may want to characterize it in a different way, but the concept is to understand that you are allowed to ask for discoverable information unless it's subject to some privilege. Now, when you ask for things and people redact things that are not just the social security number of somebody, you can almost always get an order compelling those documents as long as you argue that that goes to, let's say it's allegation number 27 of the complaint. I asked for the documents to support it. He sent back documents that were blacked out. I have no idea. You can't offer a document, sword and shield, but only offer part of it and then say, I'm not going to tell you the rest of it, when you're saying it supports your complaint. Now, it's attorney-client privilege. Okay, so I'm not allowed to know the bad things that you talked about with your lawyer. I'm only allowed to know the unredacted portions that you talked about with your lawyer. Very powerful stuff when people redact things. Little note about redaction and computer technology. When you send a Word file to someone, let's say you've done 3 edits on the Word file and you send it in final to someone. If you send it to me, I can go into that file and tell you what changes you made. What? I tell you what, Scott, I got you. I'm going to do a PDF to you. I'll send you the PDF. You send me the PDF. I can take off the blackouts and take off the data and find out what the metadata underlying that is. You actually have to do something called flattening, and there's some other techniques where essentially what you're doing is you're telling the computer to take a snapshot, a picture of it, rather than create it into a document. These are techniques that are important to understand when you're engaging in redaction or when you're trying to beat redaction. Now, you can do the old-fashioned way. You can print the document and then scan it back in. That flattens it too. But who's got time to do that? Okay? So keep in mind, when you are redacting, why you're redacting. You better have a good reason why you're redacting. And it's very hard to redact when you're offering it in support of a claim or a defense. So keep that in mind when you get redactions or when you're redacting. When you are producing documents, you should bait stamp them. And there is probably one exception when you shouldn't bait stamp them. Never! Always bait stamp, electronically stamp, identify. Why? I don't want the guy claiming or the girl claiming that I didn't give them document number 246, and now they're prejudiced and their life is over and they have to go seek psychiatric help. Okay? I want to be able to say, I am producing documents 1 through 242. They are responsive to quest number 1. The outline of these documents are 1, 2, 3, 4, 5. Now, just so you know, I'm being generous because the rule says when I produce documents, I have 2 options. Option number 1, produce them in the manner in which they're kept. They're suing the lawyers. They say duplicative, unnecessary, wasteful. We want all of your files, all 120 boxes. They have completed the case, sent the boxes to storage. They're still in boxes, but they're certainly not organized in the exact same way. They produced the documents, 120 boxes. Most of the notebooks are numbered, but not everything's in the order. Not all the pleas are in order. The other side goes bananas. You need to reorganize these. That's your duty. Sorry, you need to take a look at the rule. So I can produce documents in the manner in which they're kept. And in the answer I put, we are producing 27 boxes, 6 boxes, 4 boxes, a green notebook that has a ribbon on it, a red dot, 4 stickers, and 3 help me's. And they'll be available or they're being delivered to your office. Now, the other thing I can do is I can take the documents and I can tell them what they're responsive to. These documents are responsive to quest number 1. Okay? When somebody sends you a box of documents and says, these are responsive to your request for production, you take the documents and you deliver them back to them. And you tell them that that's not a response at all. You must say, what specific documents relate to what specific request. And by the way, just so you know, technically, under the law, can't do this in interrogatories or production. You cannot say in number 2, see number 1. That's wrong. Interrogatory number 8, see interrogatory number 4. Are you that lazy? I mean, have we reached such an epic proportion of laziness that I cannot copy the paragraph? It is so arduous, so incredibly hard to take that allegation and move it 7 inches. You cannot use other, they all do it. Not proper. Okay? So if I produce them by categories, I have to say these documents are responsive to number 1. If the documents aren't organized in a way that you could glean the understanding, they got to do that. Now, I'm not talking about they got to make pleading files, but they can't hand you 10, 15-page letters and all of them are mixed in order. And page 1 through 15 is not together. They have to send you them when an ordinary person would be able to understand them. So when people send you boxes of documents or groups of documents and they're selecting them as to a number, what you want to do is you want to get them to tell me, hey, this is why. I got these documents from you and there was a box of documents. It was a white box with 3 Happy Me stickers on it. And I wanted to understand what your responses are. I don't want to file a motion to compel. Am I to understand that every one of these documents that's listed in this box is referenced goes to number 1? Or are there different documents in different categories? Or I don't understand the categories. Let them write back to you and say, we have no duty to do anything and we don't have to duty to duty. And the duty is duty-ful. Okay? You do that, you write the nice letter, I don't want to have to waste the court's time. I need you to help me. If you're smart on your side, you shouldn't bury documents. Okay? And you should say, these documents, base stamp numbered or electronically stamp numbered 1 through 462, P1 to 462, D1 to 462, P first request 162, 1 to 162, however you want to denote it. And if you talk to the talented copy scan people, they'll tell you they can make multiple types of stamps and so that you can track what documents are coming on what request. Okay? Or if you actually are savvy, oh my God, you could sequentially number the documents. Then when I do my second request, I'm not starting all over again. Who are these people? I want to meet the people who do 1 to 362, 1 to 48, and 1 to 367. Right. McFly! Yes, ma'am. The question is, can you, in a response to request for production, just signal and put number 1, like a stickum that says number 1, and that goes to number 1, and a stickum that says number 2? The answer is, in your response, you are supposed to say what documents are being produced and not see tab 1. You are supposed to do that. People don't do it, but you're supposed to do that. And every time they don't do it, file your motion. First time they may not want to give it, just keep filing motions to make sure that, Judge, I'm entitled to know. So I don't have to come into you, Judge, 3 days a month for the next 6 years. I'm asking for what documents are responsive. And if they're not responsive, then I want to know how I can glean from that, even if that person disagrees with me. So if I'm responding and I say base stamp numbers 1 to 43, I don't have to say base stamp number 1 to 40 that comprise the following letters, the following emails. You want to do that, that's fine. But you still need to say, you don't say 1 to 362 and that's responsive to all of them. C number 1, C number 1, C number 1, C number 1. Doesn't work that way. You're not allowed to do that. If somebody does it, you definitely need to file a motion to compel. Yes?
Well, I'm just saying, if the documents aren't faithful, let's say they're asking for the insurance policy.
Okay.
Can't you just say, okay, number 1 attached?
Okay, the question is, let's suppose that the documents aren't stamped for whatever reason and that you're going to produce an insurance policy. Then you should say in your response, a copy of the 16-page, 48-page insurance policy is included in tab 1, is included in the box, is included in a bow with flowers, is included. You still should define, and especially things like insurance policies. Insurance policies, depending on when you ask for them, are 6 different numbers of pages. They're the policy, and then the riders, and the endorsements, and then I forgot that, and then the original stuff that's on it, and the stuff that was supposed to be the stuff, and the stuff that is the stuff, and the stuff. You want to make sure that when you send it, you get 25 pages. If you get an insurance policy, cool tip number 43, if you get an insurance policy, and it's 23 pages long, as soon as I get it, I push the button. Request for admissions. Please certify, please admit that the 43 pages or 23 pages in this policy comprise each and every part of the insurance policy in this case. Boom! For those who want to bill, billing. But more importantly, now if the person writes back, oh, no, I thought you meant the insurance policy without the riders. I thought you meant. Now, if you have good definition sections, when you ask for the insurance policy or ask for the responsive documents, you would have told them what that is. But if you don't know, make sure that you use admissions and other types of requests to squeeze down what that is. So, when I'm responding, I want to make sure that I'm either producing them in the manner in which they're kept, which is usually when it's large, or I'm telling the categories, and people get away with various things, but you want to be as detailed as possible. How about this one? Probably the third most annoying thing to me. The documents will be made available at a mutually available time and place. I will not tell you that mutually available time. It will not be mutual. You will have no date, and you'll need to write a minimum of 35 letters and go on 6 motions in order to get the documents. Just so you know, okay, under the rules, you are supposed to make those documents available for inspection before the time period that they're due. You cannot artificially extend a request for production, interrogatory answers, or anything by saying they're in the future sometime. Otherwise, it would eviscerate the rule. Otherwise, if I had 3 documents, I wouldn't produce the 3 documents. I only have 3 documents. It's only that you've only asked me for this book. The book is available at a mutually agreeable time. When is that? Today's June of 2023. Go to court and get one. Waste time, spend money, waste. The rule is very clear, okay? And if you can't provide them within those 30 days, then you have to file a motion for extension of time and get an order. None of this motion for protective order. I'm not having the guy show up for depo. Motion for extension of time on day 29. That's borderline unethical, okay? You have a duty to get an order on any motion. So you're supposed to do it for. So if the person sends out a motion for extension of time, you file a motion to compel immediately. You want to call them on the phone first and say, really shouldn't file an extension, or how many days do you need? And you want to agree to 10 days and let them do it? Fine, I would write them and say, and in the future, I would request that you not file motions for extension of time, to call me and ask me for extensions of time, which will avoid me having to waste time and effort and file motions to compel that the court has to hear. See how powerful that is? Okay? So I want to make sure that if I'm going to make things available, I make them available. And what you do when you get that, as soon as you get it, you push the button. I send a letter to them, please tell me the mutual available time. Now, big time tactical stuff. Ready for this? Here's what you do. Dear Mary, thank you so much for your response to request for production, wherein on numbers 5, 7, and 9, you provided the following answer to the following question. Cut and paste, cut and paste, cut and paste, cut and paste. Okay? On all 3 of those, you can see that you said a mutually agreeable time in place. I am providing you with 37 days that I'm available. Not, please send me days. I am providing you my 37 days of availability. Do not provide less than 12. Do not provide provide 37 because why? Judge, I gave him 37 dates. I'll tell you, I've done this to judges. Hey, Judge, here's my calendar. I'll turn around. You pick whatever date you want, and I'll show up. But they can't say never. And they can't say, I'll get back to you. And they can't say, well, my mother's dog's uncle's mother's ate the food that killed the dog that bit the homework. Or can't do that. So you immediately send out the request. And what do? Being the guy that I am, I number my letters. First request for mutual inspection dates. The next day, second request. I give them 3 or 4 days, 7 at the max, okay? And I say, if you don't do that, I got to file a motion to compel. Maybe they want you to file a motion to compel. Fine. I file a motion to compel, and I'm like, Judge, I would like on the record, so that it's clear, that you inform counsel that my future production requests will not be met with the same sort of thing. And every judge, even the judges that aren't necessarily strong, will say, come on, next time you better tell them. And if they don't, I'm filing my second motion for sanctions. But when you go in to do your motion to compel or for sanctions, that the person isn't responding, okay, and you go in, if you've taken 3 letters in, hey, I wrote you the first time, I gave you 17 dates. I haven't heard from you. It's been 2 days now. I need to see those documents. I gave you 17 dates. You really need to help me out here. Letter number 3, it's obvious that you don't like me. And you have something against me because I'm asking simply to have you provide the documents that are already overdue in past 30 days. We're in day 47. Now, when you go to a judge, like, Judge, you think it's nothing? It is something. You want to see my happy face here all the time? No. Okay? Do something about it. So if you write the letters and number them, and you're also telling the mutual available, you can shut that time down. In federal court, they'll be more likely to sanction than in state court, but the bottom line is if you make a good record, even the judge that never sanctions wants to sanction. Because after a while, it's like, I'm the victim here, Judge. I'm the victim. I am simply asking for the data. And there's no new rules, okay? And after a while, what happens is, what's the speed limit? You drive on the highway, it's 55. Speed limit is not 55. It's 64, 65. 65 mile an hour speed limit, it's 74, 75. Once you allow a rule to be bent, it now becomes a new rule. Now the rule is file mutually available time, inspection date, and and also where you inspect. Where do you want to inspect the documents? Okay, you're supposed to, in your response, tell them where they're inspected documents. Because some people say, well, the documents are at a warehouse, but I have to bring the documents to my office. And that's going to take time. Well, that's interesting. Did you think about that within the 30 days? That it was going to take time for you to bring boxes over? Dear so-and-so, I was surprised to learn that you're first now telling me in day 47 that you have to bring boxes over that are responsive to the documents. When's that going to happen? So what you're doing is I don't care what they say, you're documenting. So, generally speaking, they have to make things available to where you can inspect them. Some people do it at their office, some people go to a warehouse, whatever. If you go to a warehouse, then the document has to be in a place where you can find them. We once had a document request where they responded with 1.5 million documents. They were contained in 380 boxes in a warehouse with 7,000 boxes, unnumbered. And they said, it's somewhere in that corner. Don't look at me. I'm just the warehouse guy. Okay? So make sure you understand that. And again, when you get documents, if you want to think ahead for trial, as soon as you get documents, you push the button, you can send an admission request. I'm showing you what, or I'm attaching what has been marked as Bates number 1 through 23, or the insurance policy. Please admit that this is an authentic copy, or this is an admissible authentic copy, or this is authenticated, or all foundational elements. There's no need for records custodian, however you want to say it. Now that document goes in my trial file. Because now I don't have to worry about calling in the records custodian, the warehouse guy, to say, I don't know, I'm just the warehouse guy. Okay? And it's hard for them to deny that. Oh, you deny it? You denied it. You denied it. This is not the complete copy. I'm confused. I mean, if they deny that, What a nightmare that is for them. Now you're producing documents which aren't complete and aren't really authenticated and aren't really real. What are they, fake? Are they forged? What did you do? They're in a world of hurt. And what's important about that is if you do that systematically, you won't come back to trial a year later and try to find all the documents that you produced. And then what I create is I create a numbered list. So I've got my exhibit list running from day one. When I get my documents, I'm already talking about what exhibits they're going to be. And if I get them authenticated, I've got my Excel spreadsheet or my chart or whatever software program you're using, and I've got authenticated done. And I've got certified copy or whatever it is. I've got agreed to admissibility or whatever it is. And then from time to time, I can do it. Now I come closer to trial, I've got all the documents. I'm not looking back and trying to find the documents I can't find. And when you get documents in production request, do not make the mistake of just putting them in a file and putting them away. Make sure that if I came to you and said, I need the insurance policy, you don't say to me, I got to go look at the boxes. You better say to me, it's in box 3, 7 inches in, at a right angle to the moon's axis, and if you want, I'll have it to you in less than 12 seconds. Start your timer now. Because if you can't find them, it becomes very unproductive to you. And secondly, in terms of habitual systems, if you create systems, like I'm a color coding guy, I'm a gray animals guy, match the color to the color, I'm happy. So red signifies something, green signifies something, yellow signifies something, all the different colors, and then you could have different kinds of, your boxes can be identified by color and things like this. And then anybody can find the discovery or the production requests or whatever it is very easily and very simply. And you're not just stuffing them in the accordion files in discovery, and then when the lawyer says, what's this discovery responsive to, you have to go, well, I'm not really sure myself, but if you give me some time, I'll go backwards and try to find out the things that I know I don't know. Okay, so really important when you get documents, manage them. Manage those documents. Every single time. One exception. Never! Okay? So, very important that you do that because those documents are going to be guides. Now, answers to interrogatories, answers to requests for production can provide you with information that make you want to ask for more information. So you always want to look at, first, did they fully respond? If they didn't, it might be a motion to compel better responses. If they did respond, figure out what those documents are being used for. If you ask, please provide all the timesheets or all the documents that are related to the wasteful, unnecessary, unreasonable, and they produce 6 bills, okay, and you look at the bills, and that total is less than the total we're asking for in their complaint. We're asking for $1 million. The bills total up to $403,000. Everyone would agree with me, something is awry. Okay? So by looking at the answers and going back to your relevant pleadings, you can then check and see, you may want to send an interrogatory out. You have produced documents in response to request for production number 3 that says, bang. Your answer was to produce 6 bills totaling 28 pages using 20-pound paper at a weight of, here's all the things, and we have your complaint or some other answer to interrogatory or some other request that said that you're claiming $1 million when there's $403,000. Please explain. That could be an interrogatory, that could be a letter, that could be a request for admissions. Please admit that the $403,000 is all you're claiming. If they deny it, wait a minute, you denied it? Okay, so which is it? It's $1 million. Okay, why'd you only give me $403,000? Well, the dog ate him. What are they going to say? I'm not telling you. Mommy, you have to respond or you lose your claim. Remember, if the person doesn't provide the defense, if they have no basis for their denial, if they have no basis for their affirmative defenses, then this all ties in. If you do a really good job, then you can conjoin these with, in Florida, 57105 letters and federal court rule 11 letters that say, you have made this allegation, you have produced no documents, you have a duty to withdraw that allegation. If you don't, you're going to subject yourself to sanctions. So everybody now understands that these are all point of a purpose. Everything that we're doing tactically is setting up for that warfare, is setting up for, I'm going to squeeze them down, I'm going to squeeze them around. I teach a seminar for advanced lawyers, some of the top lawyers in the country, and when I was teaching the seminar, we talked about persuasion tips and getting people to commit to things. And I would have one of my many sayings. This particular saying was, I don't care what a witness says so long as he says it. Let me say that again. I don't care what a witness says so long as he says it. I don't care what their answers are. Whatever they are, that's their bed. Whatever they are, either one, tell me that your request was wholly inadequate, you're a moron, you're incompetent, you're stupid, you're this, you're malicious, or give me the information. One of the two. I don't care which one. I've been in depots with a lawyer interferes, and I'm like, if you'd like to testify, lawyer, I don't care who answers. I don't jump back down the lawyer and say, suck and fuss, and you're shut up and don't, unless they're testifying, in which case I ask the reporter to swear them in. But the bottom line is that I don't care who answers the question, I just want the question answered. Once you get the answer, they have to live with that answer. It's under oath. So when you get your documents, you're looking at, did it support the defense? Did it support the claim? If it doesn't, I'm immediately going to my lawyer, or I'm drafting the motion to strike, motion for summary judgment. I do it all the time. If I send out allegations and somebody puts none on any one of those, the next day a motion for partial summary judgment, motion to strike allegation, whatever that is, because it's not relevant, because they haven't produced any information. So you've gotten that. And in terms of the objections, you can apply the same formulas you apply in the interrogatories, in the sense that you need to be directional. If you're going to make an attorney-client privilege, you need to create a privilege log and create that list of documents so that somebody can review them. You're going to need, if you have objections based on that it's too broad. And let's just talk a little bit about that so you understand. If I make an objection in a request for production that it's overbroad, this actually applies to interrogatories too, I must produce all documents that aren't overbroad. I don't get to say, I asked for 10 years, so I'm not going to produce any, and I'm going to say it's overbroad. If I don't produce the 1 year, motion to compel. The rule says that you must do that. You cannot avoid producing by using an objection. Okay, we're going to take our next break.